All rise.
Please be seated. Thank you, Mr. Garmananda.
Commissioners, Mr. Evans would like 5 minutes to finish up. That's convenient to you.
It was actually 5 seconds, Commissioners. Commissioner Jenkins put a question to me about Mr. Sarquis and his status. He was watching remotely and contacted us to inform me that he had in fact retired during the course of the last few months, and is purely an ordinary member with no executive capacity at the present time. Thank you.
Thank you. Mr. Garmananda.
Thank you, Commissioners. May I begin by thanking Commissioners this opportunity to make submissions on behalf of the Crown entities. In these oral submissions, Crown proposes, as set out in the required summary of oral submissions, to address the following 8 topics. 1. The framework for the assessment of suitability. 2. Crown's remediation program and developments in risk, audit and culture. 3. The matter of governance and associated corporate structure issues. 4. Crown's AML CTF program. 5. The steps taken to minimise criminal infiltration. 6. Crown's communications with the GWC in the past and its commitments as to the future. 7. The financial stability of Crown and the absence of tax issues. 8. Crown's approach and initiatives as to the responsible service of gambling. Before addressing these matters in turn, a couple of matters ought to be recorded. First, this oral presentation, being a distillation, does not address all of the matters set out in writing or reflected in documentary materials before the Commission, and a failure to address something written by the PCRC or by other interested parties is not acceptance of those matters. Second, consistently with the position taken in the Victorian Royal Commission, Crown has made a number of concessions about its past conduct. That sits conformably with the approach Crown has taken to the task of remediation, recognise and understand the issues and set about to remedy them and put systems, policies and practices in place to deal with and properly address the relevant issues. Turning then to the first topic, framework. Crown's written closing submissions seeks to assist the Commission in relation to the framework for assessing suitability under the terms of reference, including Crown's answers to the various conceptual questions posed by the PCRC's discussion paper on suitability. There are a number of key points to highlight. As to the question of suitability, as the Commissioners well know, the terms of reference directs the Commission to inquire into whether Burswood nominee is a suitable person to be concerned in or associated with the organisation and conduct of the gaming operations of a licensed casino, and whether each of CRL, Burswood Management and Burswood Limited is a suitable person to be associated with the licensee. It is not suggested in our written submissions that it is relevant to consider a shareholder who is not exercising control relevantly over the licensee or other constituent bodies. CPH's shareholding is not presently relevant, particularly in circumstances of the undertakings given. The Commission is also directed to determine what, if any, change would be required to render an entity suitable if it is not presently suitable. The capacity to make recommendations is not preconditioned by a finding of unsuitability, though there may well be implied limits on the scope of recommendations in the sense that any recommendations should fairly relate to matters that were properly the subject of the PCRC's inquiry. The statutory roles and powers of the Minister and the GWC must be respected and should not be usurped. That is a point made by the GWC, and it follows from the language of the Casino Control Act. As to the place of public interest under the terms of reference, there is a real question over whether public interest is within scope or beyond scope. In Crown's respectful submission, the most obvious construction of the terms of reference would not see public interest covered. If a contrary view is taken, a problem remains in that there was no direct nor sustained inquiry into the public interest, enabling fully informed findings to be made on a proper evidentiary basis. So if public interest were captured, it is not apparent how that aspect of the terms of reference could properly have been discharged. When it comes to the assessment of suitability, one has regard to the concept of suitability under the Casino Control Act. In that Act, the concept makes its appearance in various sections, and when it does, the language used is narrower than that used in the terms of reference. The Casino Control Act's language is concerned with reputation, financial status, and capacity. Those words seem clear in their meaning. The factors at item H of the terms of reference are not exclusive, nor are they mandatory. Those words are broad in their application. There is no correspondence between the definition as found in the Casino Control Act and that found in the terms of reference. The concept of suitable person under the terms of reference is distinct and it is broader. In our submission, effect should be given to the plain meaning of the definition under the terms of reference. The GWC's reply submissions suggest that this is somehow reflective of a forensic choice made by Crown. That submission is not understood. Crown's written submissions give effect to the ordinary words of the terms of reference and the Casino Control Act. The words used are different. That must reflect a conscious choice by the draft person in circumstances where the terms of reference were drawn in the face of language available under the Casino Control Act, but not adopted. That had nothing to do with Crown. So the GWC's proposition of a forensic choice should be disregarded. When it comes to temporal considerations, as seems common ground, the inquiry is grounded firmly in the present. The past is relevant, but the question of relevance requires careful analysis and cannot be glossed. There must be attention to whether, judged by reference to people or systems or both, one can see change. In Crown's submission, evidence of the past relevantly bears upon present suitability in a number of aspects, and we've identified 3 in writing, but 2 matters are critical. First, have the deficiencies of the past been adequately addressed so that the public can have confidence that the failures will not be repeated? In other words, past failures may continue to inform the adequacy of Crown's present arrangements. Second, does particular past conduct have an ongoing and continuing effect on Crown's present character and culture? In our submission, the past has no broader relevance to present suitability. For example, the public cannot reasonably or actually entertain doubts about Crown's present management of MLTF risk by pointing to employees who are no longer associated with Crown or to practices that have been abandoned, unless it sounds in present inadequacy of systems or a persisting defect in character. That then leads to the third aspect of the temporal prism through which this Commission must conduct its inquiry, and that is considerations as to future evolution. What is reasonably foreseeable needs to be taken into account. As to the suggestion made this morning about the unidentified term long term, we would resist that needs to be brought into account. The future must be assessed, but not by reference to anything contemplated by the expression long term. It's about what is reasonably foreseeable. Crown submissions on the benchmark for assessing suitability are dealt with in writing, but 3 matters may be highlighted. First, it is not about perfection, because there would be few institutions, religious or otherwise, that would pass muster under a standard of perfection. The assessment must be holistic and not atomistic. It bears mentioning that in the observations there were countless areas where the observations recorded that certain matters were open to be found. And those open findings are addressing matters at an atomistic level. And of course, the Commission will view the matter in the round and as a whole. Further, it ought to be observed that those matters said to be open findings are not understood to be matters that required dislodging involving some casting of an onus on any of the interested parties. The third point that may be made about the approach to the assessment of suitability is that if one were to accept that the assessment should not be atomistic, if one were to examine Crown's conduct and attribute grades, Crown may not achieve high distinctions across the board, but it would, with respect, receive distinctions in some areas, and Crown has demonstrated industry and effort on all fronts. The evidence speaks to that. In our respectful submission, Crown does not presently deserve an F in any field. As to Crown's position on the appointment of an independent monitor, the following three things may be said. The independent monitor seems unnecessary in light of the existing monitorships in Melbourne and in Sydney, and the proposed recommendations to improve the operations of the GWC and empower it to become a more effective regulator. The GWC's reply submissions seek to disavow any responsibility for monitoring Crown's ongoing reform program that would seem at odds with the basal functions and powers of the GWC and would place the GWC apart from its colleagues at ILGA and the VCGLR, who have been keen to receive monthly updates on Crown's remediation program and to track progress. The GWC contends that it would not be a proper or efficient use of regulatory resources to engage in the continual monitoring of the attainment of the Crown entities reform program. The GWC has an express duty to administer all matters relating to the casino complex and the licensed casino. That's Section 7(1)(d) of the GWC Act. The GWC was conferred ample powers for that purpose. It has been given all such powers as are necessary to carry out its duties. That's the GWC Act, Section 8(1). The powers expressly conferred upon the GWC necessarily contemplate that the duty of administration would encompass monitoring the suitability of the casino licensee and its close associates. So much is evident from the power to give directions to the casino licensee, including as to the provision of information and records, the power to require closest associates to divest themselves of their interests if the associates are not thought to be suitable, the power to recommend the holding of inquiries, and the power to make recommendations to the Minister as to whether or not it is in the public interest that a casino licence remain in force. The legislative regime makes clear that such monitoring does not cease during periods of transition and change. So not only would it be proper for the GWC to monitor Crown's reform, it is already firmly within the ambit of its duties. The GWC may consider that to be not an efficient use of regulatory resources, but that is, with respect, beside the point. One other matter ought to be observed with respect to the assessment of the evidence before this Commission. There was no real evidence of industry practice. This may colour the assessment of Crown systems, processes and operations. The PCRC is left to form an assessment of Crown suitability to organise and conduct the gaming operations of a licensed casino without the benefit of a clear industry yardstick against which Crown Perth's organisation and conduct of gaming operations might be compared and measured. This is a matter to be borne in mind when considering the adequacy of Crown's remediation program. I ought to observe one thing in relation to the reply submissions and the approach taken by Crown with respect to submissions generally. We had understood the invitation to provide submissions in chief and reply was extended to interested parties to enable their comment on matters pertinent to their particular interests and to afford some measure of procedural fairness to those whose interests stood to be affected by potential findings. Crown's reply submissions do not treat the submissions of other parties as pleadings. Some of the other parties' reply submissions may betray a different approach. Insofar as there are matters canvassed in those other submissions, Crown rests on its written submissions, particularly with respect to Chapter 2, and does not now consider it appropriate to engage on all points raised in the various of the replies. Turning then to the topic of remediation. In this part of the oral submissions, I intend to address Crown's remediation plan and the substantial progress already made, significant improvements to the risk management and internal audit processes, and the advances in relation to cultural reform. In summary, the people, systems and procedures being assessed by the PCRC are fundamentally different to those in place when the cultural and risk failings identified by the Bergen inquiry occurred. Crown has a very different and improved corporate culture and risk management today. The PCRC should be satisfied that there is the competence, commitment and resources required to drive Crown's reforms to their conclusion. Crown's remediation plan is a serious, well-considered plan. Its objective is to implement and embed best practice governance and management throughout its operations. It applies to the whole Crown Group, including Crown Perth, and covers the following key areas: corporate governance and organisational structure, the CPH relationship, culture, risk management, AML CTF compliance, junkets, persons of interest, significant player review, audit and assurance, and responsible gaming. A core component of the remediation plan is the improvement of Crown's governance and oversight functions through better people, better systems, and an improved culture. Delivering best practice in critical functions such as AML is facilitated by having a corporate group with substantial resources and multiple assets, and then working with dedicated teams based at each of the properties, including Crown Perth, to implement those practices having regard to the particular requirements of the Perth Casino. The remediation plan is a living document. It is updated monthly and provided to various regulators, including the GWC. Crown agrees that it is open for the PCRC to find that the remediation plan is subject to further changes following ongoing inquiries. Crown's desire to continue to reform and improve itself reflects positively on Crown. Crown has devoted and will continue to devote significant resources to the relevant reform tasks. Substantial progress has already been made in designing and delivering the reform program. The ultimate aim of Crown's reform program is not only to satisfy regulatory expectations, but to surpass the standards of strict legal compliance and restore the trust and confidence of Crown's regulators and the communities in which it operates. The evidence of both Mr. McCann and Ms. Ward was to the effect that the remediation process is well progressed. The PCRC should find that substantial aspects of the remediation plan have already been completed or are in the course of being completed. Although the plan covers many areas and requires a large amount of work to complete, there is a sound basis to conclude that the plan will be fully implemented and completed. The combination of commitment and competence of executives and management, together with the completion of many items to date, and the appointment of an independent expert to monitor the effectiveness of the remediation plan, grants confidence that Crown will deliver on the outstanding aspects of the remediation plan. As Commissioner Finkelstein acknowledged, Crown has, at great financial cost, embarked on a significant program led by people of goodwill and skill. Commissioner Finkelstein accepted that important steps towards reform have been taken and that the program is likely to succeed. He concluded in relation to Crown Melbourne that it has the will and capacity to reform itself. Those assessments with respect are also relevant to Crown Perth, particularly as a result of the significant reforms which have already been implemented. It has allocated significant resources to the remediation project and has already made significant progress under new leadership, including directors of Burswood Limited and CRL. Further, to assist in implementing the remediation plan at Crown Perth at an operational level, there is a Crown Perth plan about which evidence was received. Crown agrees that it is open for the PCRC to find that 1. The directors of CRL and Burswood Limited have experience in leading remediation or transformation programs in large corporations. 2, its executives and management are committed to delivering on the remediation plan. And 3, based on the views of experienced directors, the executives and senior management who have been recruited as part of Crown's program are competent to deliver on the remediation plan. Relevantly, Commissioner Finkelstein considered that the most important step towards reform was the appointment of a new board and new and highly motivated senior executives. That has been done. Many of the directors of CRL have been attracted to the pathway of transforming Crown. As Ms. Ward observed, it is the challenge of restoring the trust and confidence of Crown's regulators and the communities in which it operates, and restoring the pride of the people who work for Crown to be part of Crown. I move now to the topic of risk. As observed by the PCRC, given that the ultimate question about suitability is a point-in-time exercise, it may be satisfied that the steps or measures CRL has taken to remediate risk management failings, the subject of conclusions in the Bergen report, the Finkelstein report, or in Crown's concessions, are appropriate to address those failings in the circumstances. Crown has undertaken significant reform and remediation in respect to its approach to risk management procedures. Those measures are sufficient to address the identified failings. Among the many changes implemented, about which there is much written in the closing submissions, I highlight a few. Crown's risk team has increased from 1 full-time employee to 10 employees. Crown has significantly reduced the materiality threshold so that more risk information is provided to the CRL board. It has introduced escalation requirements for each level of risk to specify when risks are required to be escalated and to whom. The new role of Chief Risk Officer has been created, reporting directly to the CEO of CRL with a reporting line to the Risk Management Committee. The CRO is a member of the executive team for each property, including Crown Perth. This reflects the increased importance of risk management to Crown. Crown has developed a risk uplift plan to ensure that there is a fit-for-purpose operating model for risk management across Crown, resourced with the required capabilities, and that there is increased risk assessment in decision-making. Crown agrees that the adoption of the Deans and Deloitte risk-related recommendations and the proposed update to the risk appetite and board charters as part of the risk uplift plan are favourable developments. The PCRC should find that Crown has implemented all of the Deloitte recommendations, with the exception of changing the name of the RMS, and that Crown intends to implement all of the Dean's recommendations. It has already done so for the majority of those recommendations, subject to the approval and endorsement by the Risk Committee in respect of certain recommendations. Given that most of the Dean's recommendations have been implemented or will be implemented in the near future, there is no real prospect that Crown's risk management framework and systems will not be effective and robust by reason of any decision not to implement any number of the Dean's recommendations. Mr. Deans found that there was evidence of improved reporting of business risk and risk matters generally to the Risk Management Committee. This includes reporting and documenting a wide range of business and risk issues, reflecting the range of issues which may face Crown. Crown agrees that it is open to the PCRC to find the Crown has a plan to enhance its approach to risk management. That is largely captured by the risk uplift plan. Turning then to the matter of audit, Crown has enhanced its internal audit department with the appointment of Jessica Ottner to Group General Manager, Internal Audit. It has improved internal audit processes, including improved reporting lines, independence of the second and third line functions, ensuring access to all boards, increased resourcing, increased access to specialist resources, the adoption of a risk-based approach to audit, and the better implementation of audit findings. The Group General Manager Internal Audit, GGMIA, now has a direct reporting line to the chair of the CRL Audit and Corporate Governance Committee and a dotted reporting line to the Burswood Limited Board for matters relating to Crown Perth. Ms Ottner has direct access and a responsibility to provide updates and be accountable to the Burswood Limited Board. A quality assessment of Crown's internal audit department was obtained from the Institute of Internal Auditors Australia in October 2020. That review concluded that the Crown Internal Audit Department is operating professionally and generally conforms with the internal audit standards. That is the highest rating that can be achieved. Since commencing in her role as GGMIA, Ms Ottner has undertaken a further review as part of the remediation plan to determine any other needs to ensure that internal audit is able to respond to new ways of working at Crown. The immediate needs identified and other actions already taken are referred to as the Audit Uplift Initiative or Plan. That plan includes, for example, the approval of an annual co-source budget to provide for easy access to special skills and expertise as needed throughout the year and uplifting the internal audit activity reporting provided to boards and committees. Crown agrees that it is open to find that Ms Ottner, since her appointment in May 2021, has made rapid improvement to the internal audit function and that she is competent to lead the review and improvement of the internal audit function. That finding should be made given her experience, including in highly regulated industries. It should also be made given the improvements Ms Ottner has already made to the internal audit function of Crown. Crown agrees that it is open to find that Ms Ottner will implement and manage an appropriate third line for AML/CTF risks associated with gaming operations at the Perth Casino. I then move to the topic of culture. Crown agrees with the definition of culture adopted in the Finkelstein report, namely, culture is comprised of the shared values and norms that shape behaviours and mindsets within a business. Commissioner Finkelstein found that organisational culture change required a multi-stage process. The 4 steps required to effect change as identified by Commissioner Finkelstein are: undertake a deep analysis of the organisation's historical culture, structure, values and practices, determine a new clear direction which is supported by an ethical and compliant tone from the top of the organisation. This may involve the recruitment and promotion of managers who will pursue the new cultural direction. Change the tangible structures, that is the organisational structure, remuneration and reward structure, and the policies and processes. And last, change the values and practices of existing employees. Taking those in turn, Crown engaged Deloitte Specialist Services to conduct an analysis of its culture, which included a review of Crown structure and policies and a culture survey used to measure employees' perceptions and experiences of Crown's organisational culture. These 2 processes formed the basis for the current Culture State Report, otherwise known as the Phase 3 report. The Phase 3 report was directed towards identifying vulnerabilities and weaknesses within Crown's culture. In order to implement a reform process, Crown needed an unflinching assessment of its existing culture, including its shortfalls and vulnerabilities. The Phase 3 report was intended to be, and was, a rigorous assessment of Crown's existing culture on a warts-and-all basis. Criticism of Crown based on the findings in Phase 3 is misdirected. Only by unearthing this material could Crown genuinely understand and remedy its organisational culture. Then, as to the second step in the 4-step process laid out by Commissioner Finkelstein, that is to develop a new cultural direction, Crown undertook the process of deciding on a new cultural direction by engaging with its employees across all properties and levels of seniority and working with them to create a new organisational purpose and a new set of values. Based on that input and with the approval of Crown's board, Crown determined a new purpose. Together we create exceptional experiences with respect and care for our community. That new purpose is underpinned by 4 new organisational values. We act with integrity, We work together, we care, we strive for excellence. Crown's entire culture reform project is directed towards establishing and embedding this new purpose and these new values within Crown's workplace culture. Mr. McCann is personally overseeing the culture reform project in conjunction with Mr. Weston, Chief People and Culture Officer. As Commissioner Finkelstein noted, a new cultural direction may best be achieved by recruiting individuals into leadership roles where they can drive the organisation towards its aspirational culture. Crown has done precisely this by recruiting new leaders at board, executive and manager level in order to develop and embed Crown's new culture. During the course of the PCRC, Crown's directors gave evidence about their commitment to changing and improving Crown's organisational culture. Witnesses including Mr. McCann, Dr. Sutowski, Mr. Carter and Ms. Ward gave compelling evidence to the PCRC about their experience in overseeing the transformation of culture at distressed organisations, their expertise in leading cultural change, and their enthusiasm for and personal dedication to establishing Crown's aspirational culture. The third step in the culture change process outlined by Commissioner Finkelstein is changing tangible structures like Crown's organisational structure and its policies and procedures so that they reinforce its new values and norms. Crown has created a roadmap which sets out the process for implementing the culture change project. Additionally, it has created a detailed culture change project plan which includes tasks and processes to be undertaken by different individuals and groups across Crown as culture change project is implemented. The project plan provides a blueprint for communications, training and induction, policy uplift, and updated ways of working. Together, the roadmap and the project plan scope out each element of the culture change project and set out the date for completion of each task. Crown has made significant progress in implementing the work set out in the project plan, with more work being carried out every week. Already, Crown has rolled out its new values and purpose across the organisation. Crown has created a group human resources function with a Chief People and Culture Officer reporting directly to the CEO, has separated the General Counsel and Company Secretary roles, and has introduced a new compliance and financial crime department, which is independent from other business units. Crown has hired highly skilled and experienced professionals to take on critical roles, including Group General Counsel, Group GM Internal Audit, and Group EGMs for financial crime risk, financial crime and compliance operations, and compliance and regulatory affairs. Crown has introduced a leadership development program, including face-to-face training sessions for all board members on CTF and AML, responsible gaming, the regulatory environment, risk strategy, health and safety, and the duties of directors. Crown has introduced new remuneration policies, including new short-term and long-term incentive policies, which make adherence to Crown's values a mandatory KPI with which all employees must comply in order to be eligible to receive financial incentives. Crown has updated its policies and procedures to reflect Crown's new values and to implement the recent learnings from the Bergen Inquiry and the Victorian Royal Commission. Turning then to changing the values and practices of existing employees being the fourth matter. This is an important step, and it involves an ongoing piece of work to which Crown, its directors, executives and managers are committed. The expert evidence given before the PCRC was that cultural change can occur rapidly, but that sustained culture change, which is something which requires more years to embed. Crown and its leaders have not shied away from this fact, and they accept that culture change requires a long-term commitment. The extent of the change achieved so far will be able to be determined when a further culture survey is carried out in the middle of this year. The survey results from 2021 will provide a baseline against which the results from the 2022 survey will be able to be compared. That comparison will provide valuable insights into how Crown's culture has progressed in the last 12 months, the impact of the Culture Change Project, and areas where further work may be necessary. The Culture Change Project at Crown began in October 2020 and has progressed well in the intervening months. The leaders of Crown are dedicated to ensuring the remaining steps in the project are undertaken and that Crown continues its progress. I then move to the issue of corporate governance and structure. In this part of the oral submissions, I cover the inherited corporate structure of the Burswood entities and why it still works, the significant renewal of the CRL and Burswood Limited boards, and the strong capabilities and commitment of the reconstituted boards, and the way in which the boards of the Burswood entities function within the group structure, improvements that have been made to governance, and the impacts of centralisation on governance. In summary, as to structure and governance, nothing constitutes a sound basis for finding that Crown is not suitable. Addressing the matter of structure. The roles of each of Burswood Limited, Burswood Nominees and Burswood Management in the governance of the Perth Casino business are consistent with the provisions of the trust deed and the state agreement. We address that in writing. Crown agrees that it is open to the PCRC to find that the government-sanctioned Burswood Limited to be the entity which governs the Perth Casino and the casino licence, a matter recorded in the observations. It has control of the legal owner and trustee of the Perth Casino assets, Burswood Nominees, and the manager of those assets, Burswood Management, and has the beneficial ownership of the Perth Casino assets as the sole unit holder of the Burswood Property Trust. The inherited corporate structure of the Burswood entity still works. That should not be surprising, as that structure was mandated by the regulatory framework, particularly the amendments to the state agreement made in 1997, following the corporatisation of the Crown Perth structure. Crown accepts that there is room for improvement or simplification of the corporate structure, but that does not tell against suitability. If the PCRC is considering recommending changes to the corporate structure, it is important that it first consider the broader implications that might arise from any such changes, such as in the area of tax or in industrial relations. Structural changes should not be imposed without due consideration of the associated challenges, costs, and risks. Turning to the topic raised by the PCRC about special responsibilities. The PCRC has referred to special responsibilities and special obligations owed by the holder of the casino licence to the people of Western Australia. Crown accepts that it is obliged to comply with the terms and conditions of the casino licence, as well as statutory and general law duties and provisions under the State Agreement, the Casino Control Act, and the Casino Manual. But it does not accept that outside of these areas, there are other legally established, well-defined special responsibilities and special obligations. The vagueness inherent in such concepts would only create practical difficulties in terms of compliance and enforcement. That should be avoided. Turning then to the matter of the composition of the boards, it may be seen that there has been significant renewal of the CRL board since the matters considered by the Bergen inquiry. All of the current directors, other than Ms. Holton, were appointed in 2021. The CRL board has a majority of independent non-executive directors with significant experience in a number of key areas relevant to the business of CRL, being such matters as risk management, regulatory engagement, AML CTF compliance, gaming management, business transformation, and cultural change. There's also been renewal of the Burswood Limited board. Apart from Ms. Fuster, none of the current directors were directors during the matters the subject of the Bergen inquiry. As the PCRC knows from media reports and otherwise, Mr. Bossy is to leave Crown Perth after close to 3 decades of service. The board has members with significant experience in key areas of risk management, that is the Burswood board, Those matters include AML CTF compliance, gaming and change management. There is a blend of representation across all important stakeholders, including an independent board member, non-executive representation of the sole shareholder and of senior management. Any proposed finding that the Burswood Limited Board is currently half non-executive and half executive is not open. There are now 3 non-executive directors, Ms. Fuster, Dr. Sitwowski and Mr. Carter. The Commission's observation that none of the non-executive directors of Burswood Limited in the period 2008 to 2021 had any prior experience in gaming or in casino risk management, including AML CTF, is not correct. Mr. Carter and Dr. Sitwowski, both appointed in 2021, have experience in the gaming industry and familiarity with AML CTF obligations and risk management. The PCRC has asked whether the majority of the Burswood Limited Board should be comprised of independent directors and whether those directors should be resident in Western Australia. As to the first part of the question concerning independence, the majority of the board is now comprised of independent directors. If the question is directed to the board being comprised of a majority of directors being independent of CRL, then that would be unusual and potentially problematic from a governance perspective. Directors independent of CRL would still owe duties and could not disregard the company's shareholder, ultimately CRL, and any utility in avoiding conflicts between Burswood Limited and the parent is likely to be illusory. As to the second part of that question, which concerns Western Australian residency, a matter of interest given the residency of one of the members of the GWC, there should be no ironclad rule that a majority of the board be resident in Western Australia. The imposition of such an arbitrary requirement, rather than benefiting the people of Western Australia, would likely substantially limit the pool of potentially suitable board candidates and, in turn, the optimal operation of the Perth casino. Whether a prospective candidate has the knowledge and experience to provide a desired degree of input as to the Western Australian community or regulatory issues or expectations must be addressed as a matter of substance. Crown agrees that it is open to find that the directors of CRL and Burswood Limited boards have experience in leading remediation or transformation programs in large corporations and that they are committed to ensuring the boards take an active role in leadership. There is no reason to question their leadership capabilities, competence and commitment. Evidence from existing CRL board members reflect, without qualification, a group of highly qualified and engaged governance professionals, each expressing in their own words a commitment to continuing the improvement of the governance practices of the Crown Group and Burswood Limited in particular. If I could address some questions which were raised about Burswood Limited and the operations of Burswood Limited. Questions were raised about the operations of the Burswood Limited Board. The weight of evidence suggests that the Burswood Limited Board has functioned as a proper board within the Crown Group structure, making decisions about Burswood Limited and the Crown Perth business. The current Burswood Limited Board recognises its role as providing oversight of the Crown Perth business and setting its strategic direction. The relevant part of the board charter is item 5.1 or clause 5.1. The function of Burswood nominees as trustee and as licensee, and those of Burswood management as manager under the trust deed, are performed for the benefit of Burswood Limited. As Mr. McCann said, the reality is Burswood Limited is in charge of the governance of Crown Perth, because all of those entities are 100% owned by Burswood Limited, and all decisions and governance as they relate to Perth Casino ultimately vest with Burswood Limited. Crown does not accept the suggestions about collective failures of the Burswood Limited Board, including as to a lack of clarity and common understanding about the role and responsibility of the Burswood Limited Board, and a failure to reach a consensus position, and a failure to proactively oversee risk management. In any event, Crown submits that it has taken steps through the board charter to provide greater clarity about the roles and reporting between each of the Burswood entities, The responsibilities of the Burswood Limited Board and the role of the directors will be reinforced by the Board Charter when it is implemented, including its oversight of the other Burswood entities and its responsibility for maintaining the casino licence. The relevant clauses are clauses 5.1, 5.2 and 5.3. Addressing the matter of centralised functions. The Board Charter states expressly the relationship between Burswood Limited and CRL. This reflects a version of a decentralised governance structure where the parent company has oversight over the overall strategic direction of the group, but the responsibility for the business of Crown Perth rests with Burswood Limited. Within that group structure, there are some centralised management functions, the oversight of which rests ultimately with the Burswood Limited Board. The current arrangements in respect of centralised management functions has been formalised through the Board Charter for Burswood Limited. The intent of clauses 6.1 and 6.2 is that Burswood Limited remains responsible for monitoring and exercising proper oversight of any centralised management functions as they apply to Crown Perth. There are obvious benefits in having some centralised management functions within a group structure. Importantly, clause 6.1 of the Board Charter includes that the centralised management of these areas does not abrogate the responsibility of the company's board to monitor and exercise oversight in relation to these matters. Steps have been taken to ensure that the Burswood Limited Board is sufficiently informed to be able to oversee centralised functions through direct reports and expert subject matter presentations. The depth of those reports and the changes to the way in which reports are given to the Burswood Limited Board, with subject matter experts being available to explain matters, take questions, better enables the Board properly to discharge its oversight function in respect of the business of Crown Perth. Turning then to the matter of the head office requirement, a matter addressed during the course of the hearing, this has been addressed in writing, but 3 short points can be made. First, Crown does not accept that it has not complied with this requirement. As a matter of fact, Burswood Limited is a decision-making and deliberative body. As a matter of practice, both the day-to-day management of the business of the Perth Casino occurs in Western Australia, and Burswood Limited, as the body with the governance responsibility for Perth Casino, meets and performs its functions in Western Australia. Second, if the PCRC finds differently, Crown submits the finding should have no consequence in relation to present suitability. CRL and Burswood Limited have historically acted in a manner which sought to ensure that central management and control was located in Perth. If they have, on a retrospective analysis, failed to do this, their default was not intentional, and there is a remedy within the state agreement for dealing with such defaults. Mr. Carter, whose evidence the Commission received, is committed to ensuring the effective implementation of the governance structure reflected in the Board Charter. Third, there is an open question as to the continued utility of this requirement as it is currently worded, where reliance on the physical and geographic presence of a head office is becoming less relevant in determining where the central management and control of a company rests. Moreover, after a world with COVID, things such as physical and geographic presence may well be much differently conceived. Addressing then the points about AML and CTF. The written closing submissions address Crown's AML CTF suitability and provides Crown's response to Section 4 of the PCRC's observations. The written submissions summarise the AML CTF landscape in which the Perth Casino operates, including the background AML TF risk and the key features of the AML CTF legislation. There are perhaps 3 points which bear particular emphasis. The first is that the nature and scope of the MLTF risk faced by Crown today is quite different to the situation first confronted by the Bergen inquiry. This is a practical consequence of the various changes and reforms that have occurred since that time, including, for example, the closure of the Riverbank and South Bank accounts and the cessation of problematic transactions such as third-party transfers and cash deposits. The risk profile has changed materially. The second point is to emphasise the distinction between actual money laundering activity and activity that is potentially indicative of money laundering. An activity may be caught by Crown's AML controls or flagged by an expert's review and require caution and further investigation, but that does not necessarily mean that actual money laundering has occurred. This is the point explained in one of Deloitte's reports to which we make reference in writing. Unusual activity must be considered on a case-by-case basis with a view to obtaining a complete picture of the facts in order to reach a concluded view. It follows that a degree of caution is required before conclusions can properly be drawn from any isolated example that has arisen in the course of the evidence. The third point is to say something briefly about the AML-CTF Act and rules. We deal with the legislation in some detail in section B2 of chapter 5. The core of the legislative regime is for reporting entities to establish and comply with an appropriate AML-CTF program in order to identify, mitigate and manage the MLTF risk that they reasonably face and to report various matters to AUSTRAC. It is not the object of the legislation and rules to eliminate all MLTF risk. These matters form a key part of the background matrix informing the assessment of AML-CTF suitability. Our written submissions are then organised around the three main areas corresponding to the three main planks of the PCRC's conception of AML suitability. And those three areas are Crown's past failures, Crown's present management of MLTF risk, including compliance with the legislation, and third, Crown's future plans for continued enhancement. I propose now to highlight a few of the key points across each aspect of suitability. With respect to past failures and Crown's response, I've already spoken about the relevance of the past to the assessment of present suitability under the terms of reference. To recall, in Crown submissions, the relevance of the past goes principally to two matters. First, whether past deficiencies have been adequately addressed, and second, whether past events continue to have some ongoing impact on present character. For the reasons developed in Chapter 5, Crown respectfully submits that it has earned a passing grade on this aspect of the suitability question. Crown has implemented a raft of changes and reforms to address the AML-CTF deficiencies of the past. We detail those in section D1. Alongside specific reforms directed to specific deficiencies, there has been a wholesale reconception and reorientation of how financial crime is addressed at Crown through the Financial Crime and Compliance Change Program, FCCCP. In short, Crown now has a complex financial crime and compliance structure, staffed by a team of over 100 with a broad spectrum of financial crime experience. It could well be the most sophisticated financial crime setup in the casino industry. The effect of these changes and reforms is that the deficiencies of the past have been appropriately acknowledged and addressed. The second dimension of the past is the impact, if any, of historical failures on Crown's present character. In Crown's respectful submission, there is no continuing impact. Crown has accepted its historical failures and embarked upon a comprehensive program of reform, made appropriate concessions, and demonstrated insight. Many persons the subject of attention in section 4 of the observations had already departed Crown before the inquiry and are no longer associated with the business. Names such as Mr. Felstead, Mr. Barton, Mr. Preston. More recently, there have been other departures, including those of Mr. Bossy, Mr. Brown, and Mr. Cosson, each of whom received some attention in section 4 of the observations. There are a number of new post-Bergen recruits, being Mr. Carter, Mr. Morrison, Mr. McCann, Mr. Blackburn, and Miss Slattery, and each of those have received positive endorsements, placing Crown in safe hands with respect to AML-CTF risks. It follows that the organisation today is not the same organisation that enabled the AML-CTF deficiencies of the past. Recalling the International Sporting Club decision, the material change in the composition of Crown is significant in the assessment of the relevance of past conduct to present character. The written submissions identify how Crown presently manages its MLTF risk, which is the second aspect of the analysis. Crown's AML CTF systems have received what is probably unprecedented attention from industry experts. Some of the main reports are listed in writing. There are 18 separate reports, this is paragraph 138 in chapter 5. There are 18 separate reports noted there, not including other reports such as those of McGrath-Nicol. Crown has taken or is in the process of taking steps to implement the experts' recommendations, and we deal with that in writing in Appendix 5C. That considerable expert work has fed into the Financial Crime and Compliance Change Program and provided the background to the revised joint AML-CTF program adopted by Crown in December 2021. The details of the new program are set out in the closing submissions. As explained there, the program meets all of the requirements of the AML-CTF legislation and is supported by an enterprise-wide risk assessment. The program is being subjected to an independent expert review by Exeger in accordance with the AML-CTF rules. That review is underway and is due to be completed by the end of March. There is no evidentiary basis to conclude that Crown's AML-CTF program is deficient or non-compliant. The PCRC received evidence from Ms. Waldron about the predecessor November 2020 program. That evidence has been overtaken by the December 2021 program, but in any event, the written closing submissions set out in some detail why it would be unsafe to rely on Ms. Waldron's opinion in the circumstances attending her review of the November program. The available evidence indicates that incidents of activity potentially indicative of money laundering have fallen in conjunction with the AML-CTF changes and reforms. The Exeter review provides an additional layer of comfort, and the results of that review can be reported when available. For these reasons and those set out in the written submissions, it is open to find that Crown is presently addressing its MLTF risk in an adequate manner, consistent with the requirements of the AML-CTF legislation. As to the future plans for the AML-CTF regime, these matters may be observed. The Financial Crime and Compliance Change Program places Crown on a trajectory towards continued uplift and the attainment of a higher level of maturity. The evidence is that Crown remains on track to achieve an advanced state of maturity by its target of the end of 2022. The PCRC raises a finding that Crown's AML-CTF suitability should be contingent upon the achievement of advanced maturity. Crown resists that proposed finding for the reasons set out in writing, but in essence, the touchstone identified by the PCRC for AML suitability is whether the public can reasonably have confidence that MLTF risk is or will be appropriately identified, managed, and mitigated. Advanced maturity is not a precondition to public confidence. The maturity concept is not intended to be a categorical and objective method of assessment, and the public would not see it that way. Rather, it was a measure deployed by Mr. Blackburn to situate his expectations and to ground his program of reform. Under Mr. Blackburn's metric, a foundational entity is nevertheless compliant with the laws enacted by Parliament in the AML-CTF legislation. Mr. Blackburn's evidence was that Crown is presently managing its MLTF risk effectively. The evidence suggests that even some major banks have not achieved advanced maturity, and there is no evidence of general industry practice in the casino sector as to the prevailing state of maturity. Crown should be given due recognition for its goal to achieve advanced maturity and not penalised by linking suitability to the attainment of that goal. To proceed otherwise would be to distort the touchstone of public confidence and impose a higher standard beyond industry practice and the requirements of the AML-CTF Act. Those are the matters we would highlight by way of oral submissions, and Crown's ultimate submission is that the extensive and comprehensive AML-CTF reforms have elevated Crown to a position where, applying the test identified in the observations, the public can reasonably have confidence that ML-TF risk is or will be appropriately identified, managed, and mitigated. Turning then to the topic of criminal infiltration and related matters. In writing, we address the systems and procedures in place to minimise the risk of criminal infiltration at the Perth Casino. The section covers Crown Perth's involvement in the conduct the subject of the Bergen inquiry regarding the approval of junket operators and the China arrests, and the impact of those past events on current suitability. The section addresses the systems and controls used to minimise criminal activity. These systems and controls include safety and surveillance at the complex, Crown Perth's cooperation with law enforcement agencies, and the enhancements to Crown Perth's person of interest and significant player review. Crown acknowledges its failings as they relate to the operation of junkets in Perth. That was the subject of evidence before the Bergen inquiry. Those failings are properly regarded as historic and do not bear upon Crown's current culture or suitability. Crown has taken significant steps to remedy the underlying conduct and to ensure that such conduct cannot recur. The submission set out the actions taken by the Crown Group since 2020, which evidences Crown Perth's commitment to higher standards and more effective risk management. Crown has followed the recommendations made by Deloitte in relation to persons of interest process and has withdrawn the licences of a large number of patrons. All junket operators, the subject of the 2019 junket media allegations, have been banned. Of key importance is Crown's announcement that it would permanently cease dealings with junket operators in November 2020. Crown will only recommence dealing with a junket operator if that junket operator were licensed or otherwise approved or sanctioned by all gaming regulators in the states in which Crown operates. Addressing then the China arrests. China arrest was a traumatic experience for the organisation and the people involved, and Crown's response is set out in the submissions. Crown has closed all offshore offices and the VIP international team has been integrated into the broader business. The dealings in relation to the China investigation were largely conducted by individuals who no longer work for or advise Crown. With Crown now under different stewardship, the PCRC can be satisfied that Crown has learnt from its past mistakes and will not repeat them. Crown has now been subject to 3 scorching public inquiries. Public inquiries add positively to the retention and institutionalization of knowledge and promote lesson learning and resilience with respect to future crises. With respect to measures to restrict criminal infiltrations, Crown accepts that one of the extant risks associated with casino operations is criminal infiltration. Crown's view, shared by the department, is that the risk of criminal infiltration properly refers to organised crime using the casino or aspects of casino operations for criminal purposes, rather than simply all forms of crime which might occur within the footprint of the casino. Nonetheless, Crown accepts that it has an obligation to run a safe casino. Crown has conducted its business on the basis that it has a responsibility to avoid and minimise criminal influence and exploitation. Crown does so in at least 3 ways. First, Crown maintains a safe and secure environment at the resort with well-resourced and well-trained security and surveillance teams. The Commission itself has seen how powerful the security and surveillance systems are. The PCRC has said that it is open to the Commission to find that the Perth Casino has in place well-resourced security and surveillance departments, and that the systems, policies and procedures are generally adequate to mitigate the risk of criminal infiltration. The PCRC has noted that the Perth Casino employs a significant amount of technology, including military-grade FRS and thousands of CCTV cameras, to ensure that the risk of infiltration is mitigated. Those findings should be made. Despite the adequacy of those measures, in recent years, Crown Perth as it enhances systems and controls. For example, it has doubled the number of cameras using facial recognition software, both at the Perth casino and at the resort. The second point to be made is that Crown has long had and continues to have close relationships with law enforcement agencies. The evidence led before the Commission reveals that the working relationship between Crown and these agencies, and in particular the Western Australian Police, are collaborative and effective. Those relationships have the effect of reducing the risk of infiltration. Crown's assistance to law enforcement agencies comes in many forms. Crown provides a large amount of information to law enforcement agencies. Members of both Crown and WA Police gave evidence that the volume of such information was significant and played an important role in the detection and investigation of crime. Crown assists with and causes to be initiated criminal investigations. Some of these are in respect of what might be regarded as volume crime, such as assaults, theft or damage, but others are more serious, such as the investigation and prosecution of Mr. Lin for dealing with the proceeds of crime. Crown's good working relationships with law enforcement agencies reflects positively on its honesty, integrity and competence as a casino licensee. The third matter to be observed under this topic is that Crown has systems in place to address the risk of infiltration in general, in addition to the matters concerned with money laundering. Crown accepts that these systems may be capable of improvement, but is committed to monitoring and implementing enhancements where they are identified. Nonetheless, Crown's current systems are robust and effective for the minimisation of criminal infiltration of the casino. Turning then to the topic of communications with the GWC. The written submissions address the topic of Crown's dealing with the GWC. It places that topic in the relevant context, considering the terms of reference and the appropriate standard for communications with the regulator. The written submissions covers the history and nature of the communications between GWC and Crown, dealing with the adequacy of its communications on specific topics, and considers the approach to certain regulatory questions, including about a regulatory presence at the Perth casino. The written submissions responds to the matters raised concerning conflicts of interest and addresses the matter of regulatory capture. Dealing first with the standard for assessing past communications. The assessment of Crown's past communications should not proceed on the basis that adequacy is an expression that is referable to an obligation in the current regulatory framework equivalent to continuous disclosure. If Crown is now to be judged on the adequacy of its past communications with the GWC by a standard that did not apply to it at the time of the relevant communication, there would be an element of unfairness that could not be remedied. For the purposes of item 6 of the terms of reference, Crown accepts that the adequacy of its communications with the GWC and the department can be assessed having regard to the matters noted by the PCRC in the observations. That is, the information should be objectively accurate, the information should be objectively fulsome, communication should be made honestly, carefully and with candour. These are the standards that Crown strives to meet. Crown has made frank concessions about the instances of past communications where it has fallen short of those standards. Crown's objectives in its dealings with the GWC is to foster a relationship based on trust and transparency, and its current leadership is committed to that purpose. That is reflected in Crown's apology to the GWC and the assurances given by its senior leaders. Crown accepts that specific communications, the subject of concessions in its closing submissions, reflect poorly on it. It does not seek to diminish them. Attempts to suggest that instances of poor communication reflect a pattern that bears upon Crown's present suitability cannot be sustained for at least 3 reasons. First, the more serious failings in Crown's communications with the GWC occurred some time ago. They were made by employees who have moved on and at a time when different leadership prevailed at Crown. Second, Crown's record of reporting should be looked at in its entirety, comprising daily reporting including self-reporting of operational non-compliance, attendance at the meetings of the GWC and meetings with the department, and formal disclosures by Crown, including matters of non-compliance. Third, Crown's recent dealings with the GWC and the assurances of its senior leaders reflect favourably on Crown's present suitability. Crown respectfully submits that it may be accepted that its mistakes of the past are aberrations and will not be repeated. Dealing then with the matter of conflicts of interest, which occupied some time at the hearing, Crown accepts that it is open to the Commission to conclude that Mr Connolly's friendships with Mr Hume and Mr Murray put Mr Connolly in a position of perceived conflict in the performance of his role of CCO and Deputy Director General of the Department. Those relationships have been thoroughly examined both by Crown and the PCRC. No evidence has emerged that shows that these relationships involved actual as opposed to perceived conflicts. The evidence shows that Mr Connolly, Mr Hume and Mr Murray were open about their friendship. They were alive to the fact that there was potential for a perception of conflict to arrive in some instances and took steps to manage that potential perceived conflict by disclosing it to their supervisors. In retrospect, more could and should have been done to manage the potential for a perception of conflict of interest to arise. Crown acknowledges that insufficient attention was given to whether these friendships were appropriate. Nonetheless, the evidence does not support any finding of actual conflicts of interest or of any impropriety on the part of either Mr Connolly or Crown employees, nor is there any evidence that these relationships were formed or maintained as part of a coordinated strategy by Crown. That then leads to the issue of regulatory capture. Crown submissions deal at some length with the concept of regulatory capture, including its fragilities and the risks associated with analysing an extant strategic risk in those terms. There are no settled criteria by which capture is determined. Diagnosis of capture is often made using low evidentiary thresholds and flawed reasoning. Regardless of the conception of capture that is ultimately adopted by the Commission, it is clear on the evidence that there has not been any capture of either the GWC or the Department by Crown. The evidence supports the finding that there was a close working relationship between Crown, the Department and the GWC. That close working relationship led in some instances to employees of both Crown and the regulator forming friendships. Neither the close working relationship nor those friendships are sufficient to find that there was regulatory capture, either by design or in effect. It is clear that the GWC retained its own mind and exercised its powers adversely to Crown's interests when it thought appropriate to do so, including by, of its own volition, calling for a formal inquiry into Crown's suitability. Whatever the position historically, Crown's current directors gave unanimous and clear evidence that Crown supports a robust, independent regulator. Moving then to the topic of revenue and tax. Chapter 8 of Crown's closing submissions address the topics of revenue and taxation. Crown's financial status and financial background are together one of the 5 express indicia of suitable person as defined in the terms of reference. As such, it is important for the Commission to consider and make a positive finding about Crown's financial suitability on the available evidence. That evidence, principally in the form of an expert report from McGrath-Nicol and Crown's response to it, supports a finding that Crown Perth is in sound financial health and is financially suitable, satisfying that aspect of the definition of suitable person. In Crown's respectful submission, that finding should be made in clear terms in the final report. There is a related topic of the casino tax. This is addressed in writing. It is fair to say that the casino tax received a considerable degree of attention in the course of the summonses and public examinations, leading to the provision of a position paper by Crown. The PCRC's investigation revealed that, unlike the position in Melbourne, there was no evidence of any substantive issue with respect to the calculation and payment of the casino tax by Crown Perth. That outcome ought to be recorded as a positive finding in the PCRC's final report, reflecting the evidence that was gathered by the inquiry. Crown notes that the observations were silent with respect to the substantive issue of the casino tax, even though the matter was the subject of inquiry. It would not be appropriate for there to be no finding on the substantive issue merely because the outcome of the inquiry was not adverse to Crown. The PCRC considers casino tax in the context of adequacy of Crown's communications with the GWC. The observations focus in particular on the tax treatment of tournament entry fees and of non-cashable credits across EGMs and table games. It is suggested that it would be open to find that Crown Perth did not communicate with the department or the GWC as a cooperative, open and frank casino licensee would have done in relation to those two tax issues. In Crown's respectful submission, that finding is not reasonably open on a fair reading of the evidence before the Commission. The relevant evidence is summarised chronologically in writing. In our submission, that evidence shows that Crown was open and transparent in its dealings to the point of sharing privileged legal advice, and that the Department and the GWC operated with their eyes open and formed their own views, relying on advice sought and obtained from the State Solicitor's Office. In the circumstances, the findings proposed tentatively in relation to Crown's dealings with the Department and the GWC on the casino tax are not fairly open. Moving then to the last topic on the list of topics, which is the responsible service of gaming. Crown's written submissions address the matters raised in the observations concerning the responsible service of gambling, both with respect to Crown Perth suitability and regulatory reform. Taking the matter of suitability first, the PCRC identifies possible deficiencies in Crown Perth's past approach to RG. Questions are raised as to whether Crown's leadership change and RG change program are sufficient for the Commission to be satisfied as to the adequacy of Crown's approach, leadership and culture concerning RG. Crown submissions are to the broad effect that the alleged deficiencies are overstated and do not derogate from Crown Perth's suitability when considered in context, and that there can be no doubt as to the commitment of Crown's current leadership to RG or as to Crown's capability to deliver a world-leading RG change program. Crown's written submissions deal with these matters in detail. It is worth emphasising 9 matters. First, it is not the case that Crown Perth has failed in the past to recognise its responsibility as to RG. On the contrary, Crown Perth has developed a substantive RG framework over the last decade and a half. It has had an RG team and an RG management committee since 2005. It has had RG training for all staff and a dedicated RG centre since 2009. It moved to a 24/7 operation in 2012. It has continued to develop its RG initiatives. It has reinforced over and over again the message to its employees that RG is every employee's responsibility. In the last year, it built a new, larger RG centre and substantially increased the size of its RG team. Second, it cannot be said that Crown's RG framework has been limited to a passive informed choice model. It is true that Crown has a self-exclusion program and disseminates information about RG and its gaming product. Those are good initiatives. A gambling operator should assist people who seek help and assist patrons to make informed choices about their gambling. But Crown has long had initiatives that go beyond mere informed choice. By way of example, it has a third-party exclusion scheme by which family and friends can apply to have a gambler excluded from the casino. It uses staff observations as well as behavioural tracking technology to identify customers who might require assistance or an intervention. It has an advanced facial recognition software system to identify customers breaching exclusions. It has robust processes governing whether a customer will be permitted to return to gambling after an exclusion period, as well as to monitor and assist a customer if they return to gambling. It conducts RG reviews over its marketing material and over applications for Pearl Room membership. Third, All of these RG initiatives have been voluntarily implemented by Crown Perth. That reflects positively on Crown's character. Fourth, Crown Perth cannot be said to have failed to meet the expectations of the community or the regulator in circumstances where those expectations have not been made clear or have not been specified. The regulator has not previously raised any substantive concerns about Crown Perth's RG framework. There are no regulatory or legislative directives guiding Crown as to the community's expectations. Fifth, there is no suggestion that Crown Perth's past practices have been below industry practice. Rather, Professor Rockcliffe's evidence suggested that Crown's practices was in line with industry practice. And Crown voluntarily took the step of appointing the RGAP in 2019 to review its framework and make recommendations to ensure it achieves best practice. That is commendable, not condemnable, because the experts are paid for their views. Sixth, the criticism of Crown's RG framework failed to appreciate the complexity of the area. Gambling-related harm is a multi-dimensional issue. There is no silver bullet. There are legitimate differences of opinion as to the appropriate extent of intervention and as to what measures are effective. Measures may have unintended adverse consequences, a matter on which expert evidence was received. Questions of public policy may be involved, as measures can impinge upon the autonomy, privacy, and recreational enjoyment of patrons. Crown should not be seen as failing or flawed for not taking particular steps where there is uncertainty as to their effectiveness or appropriateness. Seventh, some measures that Crown Perth has been criticised for not introducing, such as mandatory carded play and the regulation of structural features of EGMs, are properly matters for the regulator or government to consider from a holistic perspective. Crown Perth should not be seen as a bad corporate citizen for not introducing them. Eighth, Crown readily accepts that there have been some weaknesses and areas for improvement in its approach, but that does not mean Crown Perth lacks good character and capability or commitment in this area. Suitability does not require perfection. Crown has launched a transformative RG change program to address these weaknesses and further evolve its framework into a globally leading approach. The RG change program includes the development of an integrated customer data set to support RG analytics, a more robust customer risk assessment methodology, investment in technologies to enhance customer monitoring, including with respect to uncarded play, a reconsideration of play periods based on operational data, commissioning research with respect to loyalty programs and observable signs, establishing RG key performance indicators for employees, and the enhancement of Crown's RG training program. Importantly, the RG Change program includes building an evaluation framework by which the efficacy of Crown's RG initiatives will be evaluated, with the outcomes fed back into policy. There are a number of new roles specifically mandated to focus on data analytics and evaluation, including an evaluation manager in Perth. Ninth, there can be no doubt as to the commitment and capability of Crown's current leadership. The RG team in Perth is led by Melanie Australian-Fawkes. She has over 10 years' experience in the area. She has an evident commitment to her role and has long been a strong advocate for resourcing of the RG team and leading practices. The RG function is now headed by Mr. Blackburn and the new Group Executive General Manager for the RG role. Mr. Blackburn is a dynamic and capable leader. He is a direct reporting line to the CRL board and their full support for his world-leading RG change program. Mr. Blackburn has already implemented extensive improvements. The new group executive role is, to Crown's knowledge, the most senior, fully dedicated RG role at any casino globally. The person recruited to that position is an international global expert in responsible gaming with a doctorate in psychology. Crown's RG team is well advised by the expertise of the RGAP panel. The criticisms of the members of this panel are without merit. There can be no doubt as to their expertise, integrity and capability. There has been a significant increase in the resourcing of the RG team, and Crown is committed to evaluating the appropriateness of this resourcing as the RG change program progresses. In summary, Crown's current approach to RG, including its RG change program, should be seen as reflecting positively on Crown Perth's suitability. Turning then to the matter of regulatory reform. The Commission has contemplated numerous potential options for regulatory reform concerning RG and possible recommendations for minimising the risk of gambling-related harm at the casino. These are dealt with in written submissions, but three matters of importance ought to be highlighted in respect of these recommendations. First, fundamental to any such findings and recommendations is the conception of gambling-related harm. It is the keystone upon which any analysis of the causes of gambling-related harm, the prevalence of such harm, and how best to minimise it rely. Crown submissions address why a low threshold for gambling-related harm, such as that proposed by Professor Rocklov, should not be accepted. One key reason is because it would, in effect, have the Commission trespass upon the policy determination in this state made long ago that casino gambling should be lawful, and that a commercial enterprise should be sanctioned to establish and run the casino in exchange for a portion of its revenue. Each of the Department, the GWC and Crown have been at pains to emphasise that the Commission's analysis of and recommendations in respect of measures to minimise gambling-related harm must not seek to revisit by design or effect that policy decision. To advocate against a low threshold for harm is not to say that Crown views gambling-related harm as something that is only suffered by problem gamblers. Crown accepts that gambling-related harm occurs across a continuum and is capable of being suffered both by those who have a clinically diagnosable condition and those who do not. Crown accepts that a gambling-related harm minimisation strategy should contemplate that harm occurs across such a continuum. But any such conception of harm adopted by the Commission must have a threshold that is informed by and conforms to the reality that Parliament has determined that casino gambling is legal in Western Australia and that the community can enjoy the benefits that flow from recreational casino gambling. That leads to the second matter, which is that the recommendations proposed by the Commission are made without analysis of the overall impact that these recommendations may have, either alone or in combination. It was noted as essential in both the observations and by the Commission's own expert witness that such an analysis occurred because, absent it, no assessment can be made as to whether the recommendation is either proportionate or necessary. Because of this, each of the Department, the GWC and Crown have in their written submission respectfully cautioned the Commission against making recommendations in respect of these measures. Crown's position is, in the first instance, that most of the proposed recommendations should not be made for the reasons articulated, and these matters should be left to another day and another forum for fulsome evaluation. But if the Commission is minded to make recommendations as to these measures, they should be cast, as the Department suggests, in the form of a recommendation that the GWC give consideration to implementing them. That is not to say that Crown's views that the Commission has not identified any aspects of the regulatory framework that can be improved immediately. It has. For example, Crown accepts that it's open to the Commission to recommend that a mandatory code of conduct be imposed by the GWC and the recommendation to reduce the maximum bet size on EGMs on the main gaming floor to bring them in line with New South Wales and Victoria can be made. Crown's submission is rather that in respect of most of the measures proposed by the PCRC, careful consideration needs to be given to them and a holistic assessment of the impact made before they may properly be implemented. This is particularly so in respect of measures which have not been demonstrated to be effective in minimising gambling-related harm. It applies with even greater force in circumstances where the cost of implementing the measures is unknown and where such measures may have significant impacts, financial and otherwise on Crown Perth and other interested parties. This then leads to the third important matter, which is proportionality. The decision to legalise casino gambling involved the balancing of many public considerations, including harm minimisation, promotion of recreational enjoyment, encouragement of tourism, and the generation of revenue for the state. No remedial measure proposed should be disproportionate to the mischief it seeks to address, nor seek to elevate any one of those considerations as paramount above the others, bearing in mind it was the decision of the state to grant the licence under the state agreement. Given that, it is important to recognise that gambling-related harm is low in Western Australia, both in real terms and relative to the levels of harm suffered in other Australian jurisdictions. Despite that, Crown accepts that additional measures can and should be put in place to further minimise the risk that people will suffer such harm. But it should be borne in mind that in assessing the merits of the measures proposed, particularly when considered in their totality, that these measures seek to address a problem that is relatively confined, and that the object of preventing harm must be weighed with the other policy objects that the legalisation of casino gambling sought to promote. If I then say a few words by way of conclusion. Crown otherwise relies on its written submissions on the various topics covered orally this afternoon as the steps that were required to be taken before entry into the hearing room reveal tangibly, we are living in a changing world. In that world, Crown has set itself the task of changing itself. That is no small endeavour, but Crown is progressing well and on track with its remediation program. It bears mentioning that a central principle of our justice system is that we reject what Wigmore described as a human tendency to punish not because the accused is guilty this time, but because he has been bad in the past. Such a process of reasoning ought not to be followed, and that, we say, has pertinence to the temporal considerations evident in the terms of reference. One further cardinal aspect of our justice or moral system ought, with respect, to be kept in mind, and that is the scope recognised for rehabilitation and redemption. The evidence before the Commission, particularly of the program of remediation, shows that Crown has reformed itself and is presently suitable. Those are the submissions we wish to make.
Thank you, Mr. Dharmananda. I'm tempted to go first so I can take this mask off, but I'll resist that temptation.
Well, and that allows me to take mine off, doesn't it? Mr. Dharmananda, can I ask you a question, first of all, in relation to the suitability issue and the terms of reference, and you'll be aware of the two limbs of the suitability inquiry for BNL.
Yes.
And I think the parties were all asked to opine whether there was any difference or what was the difference between those two limbs. Could it be that BNL, for example, could be found to be unsuitable as a licensee because, for example, of its corporate structure, of its governance structure? I'm just, this is entirely theoretical, but then still be suitable under the second limb, in effect, to be associated with the casino licensed casino operations, and that could be what the two limbs are driving at?
With respect, Commissioner, that's an interesting reading of that section, but I don't think that's what is intended by the terms of reference.
So what do you say?
I think it's just not particularly clear drafting, and it is to be undertaken as a holistic exercise.
So what you say that interpretation that I've put is interesting. What is wrong with it, though?
Well, There's a conjunctive, not a disjunctive.
Right.
That's
Alright.
what's problematic with it.
That's what's problem. Thank you. Now, turning to the role of the public interest, I want to understand this a bit better from your perspective. Comparing what you said today to what is in your written submissions, just want to understand, is Crown's position that the public interest is not captured in the terms of reference, or that it should not be, or that is the PCRC should not assume that it is captured? Because I think the assumption terminology is what is used in the written submissions.
Well, we did use that language in the written submissions, and today what I said was, on a plain reading of the terms of reference, especially when you compare it to the Victorian terms of reference, public interest isn't mentioned.
So you say is Crown's position is that it's not?
Well, our position is as reflected in writing, which is there's a question as to whether it's covered. If it is covered, then query what the process were directed to during the course of the proceedings to address the matter of public interest.
All right. So I want to put that to one side for the moment. I'm not interested in what we did or didn't do to examine it. I want to ask you about what Crown says is the proper construction of the terms of reference.
The proper construction of the terms of reference is that public interest is not squarely covered.
Squarely. All right, I want to ask you about...
Because with respect, they're your terms of reference.
Yep,
that's why
I know.
I'm expressing it in the way that I am.
All right, that's
Yes.
fine, if that's how I'm to understand your submission. Can I ask you a couple of questions about that? The first is it possible to exclude the public interest entirely from the criteria of suitability in H? For example, when the PCRC inquires into the character of a casino licensee and whether it is a suitable person to be a licensee, doesn't the public interest play a part in determining what is the appropriate character for a casino licensee?
That inquiry as to the aspects of public confidence may well be captured within the definition of suitability. But the question of public interest, that is the broader question as to the benefits and disbenefits, that's the point of the submission that we make.
So that's what I wanted to identify. I suspected that was the case, but I want to make sure that you're not suggesting that when looking at some of these criteria of suitability, that we're prohibited from taking into account what is the public interest, for example, in the character, what standard of character is required of a casino operator, what standard of honesty is required, what does the public require by an honest casino operator.
We're not suggesting that at all. It's public interest as that term is understood in the authorities, meaning broadly matters of benefit and disbenefit to the public.
Well, I won't quibble to you about what the authorities say, because you yourself in your written submission say public interest is a very broad concept and means different things in different places. So we'll leave it at that. Can I finish this part of my questioning with asking you in respect of paragraph H small f of the terms of reference, which say that we can take into account other things, why in that respect can't we take into account what you say you mean by the public interest?
Well, there would be aspects of the proceedings directed to those other matters, including an invitation to address the public interest if that was the intent of the Commission.
But theoretically,
theoretically, if the Commission saw fit to inquire into that and steps were taken within the course of the proceedings to allow those matters to be investigated, then that would be possible, yes.
Moving on then from the public interest, you said in your oral submissions that that Crown did not accept that there were special obligations
Yes.
on the casino licensee. Your written submissions accept that Crown has a social licence.
Yes.
Can you explain to me what you regard as the difference between special obligations to be implied from the framework as opposed to the conditions of a social licence?
Well, the phrased in the manner that it was in the discussion paper as involving special obligations and responsibility without much definition, it became difficult to accept that those matters exist, just from the perspective of a practical operation of discharging those duties. But as Crown has accepted before Commissioner Finkelstein and elsewhere, it has a responsibility generated by virtue of the fact that there's a social licence to operate. As to exactly the confines or limits of that concept, it's not exactly clear. But it is brought to bear when attention is given to such matters as responsible service of gambling. These are the type of areas where it seems to flesh itself out.
So your main complaint about the idea of, or the concept of special obligations is that you simply don't know what they might be.
We don't see that as grounded in a legal responsibility, as imposing a legally defined duty.
But the same could be said of the conditions of a social licence as well.
The same may be said about that, and that's why I say that the social licence idea manifests in particular areas, as is evident from the findings made by Commissioner Finkelstein.
And in regards then, you mentioned just then the RSG context. One of the submissions you seemed to make, and I don't want to misrepresent you, but this is how I understood it, was that you were saying that one of the reasons why Perth Casino could not be blamed for having an inadequate RG program in the past was because the regulator never required more of the casino. Is that...
Well, more to contextualise the behaviour of Crown Perth, where it has embarked on a voluntary process of responsible service of gambling, where the GWC didn't call for it and where there is no mandatory code of conduct. So that is taking steps to achieve a level of responsibility off one's own initiative. So it's highlighting that Crown takes that responsibility, recognises it and takes it seriously, even without someone telling it to do something.
Yeah, so isn't that in fact saying that the Perth Casino can't be blamed for having an inadequate program because it took steps to have one? Not because the regulator didn't tell it what to do, but rather that actually it was behaving as a casino licensee ought.
Well, that's an aspect of it. That's the flip side of the submission I just made, because it's hard to say you have failed when there isn't a relevant regulated standard against which to judge that failure.
Well, can I put this to you? Doesn't the whole concept of a need for a suitable person to be a licensee carry with it the idea that that person will behave that person or entity will behave to a certain standard or level because of their character, their honesty, their integrity, without any regulation.
And Crown did that.
No, well, that's the point. So that's
Yes.
the point I'm making, Mr. Dharmananda, that you would say that is what Crown did.
Yes.
And it wasn't it's not that it can't be blamed because the regulator didn't require more. You would say that you can't be blamed because you did what a suitable casino licensee could be expected to do in the circumstances.
Certainly that's one aspect of it. The other aspect is just the traditional abhorrence of imposing a finding against someone in circumstances where it is in fact retrofitted. The law doesn't readily embrace that.
Well, that comes down to whether there is a standard that can be expected.
Yes, there's no external standard is the point that we were making.
You said when speaking about an independent monitor, and you said that one was not required in Western Australia. You said that one of the reasons of why that was because there were the existence of equivalent monitors in Melbourne and Sydney. How would an interstate monitor have any ability to monitor implementation of remediation plans at the Perth casino?
Well, as the Commission already knows, some of the functions operate under a centralised basis. So obviously the review of those centralised functions will be discharged by both Sydney and Melbourne. That's one aspect of it. So that will cover, inevitably, Perth to the extent that this function, AML is a classic example. AML will be, as Mr. Blackburn gave evidence, it's across the nation. The other aspect of that is that in the course of the work done by those bodies, inevitably, they will take an all-of-Crown approach to examine what is happening at, for example, risk management across all of Crown.
Including Perth casino?
Well, it's one of those aspects of the business that needs to be dealt with at a particular level. So they will examine relevant papers which would affect all parts of the business.
Can I ask you about a few sort of specific things? First, in relation to the Perth casino, it has no CEO at present, that's correct?
Yeah, that is so, yes.
And is there anything that Crown wants to tell the PCRC about that position and what might occur in respect of it?
Well, the announcement made about Mr. Bossy is that he's available to assist until June of this year. So in terms of a functional capacity, Mr. Bossy is available to lend assistance. There is, of course, the plan to replace Mr. Bossy with a new CEO, and I can't report today exactly how far that process has gone given the recent nature of the announcement.
And just, there was also in the same announcement the talk of an imminent appointment of an acting COO. Are you able to tell us anything about that?
I think I might be able to do so in a few moments.
Well, perhaps you can come back to that.
Yes.
In respect of the RCOL recommendations, without wishing you to give evidence from the bar table, but I asked, when these came out, I asked various Crown directors, how they, and management, how they saw those being implemented and affecting Crown Perth. Has that, there was nothing in your oral submissions about how the implementation of those recommendations might affect governance and management of Crown Perth. Is that because Crown doesn't see them as affecting governance or management of Crown Perth?
I don't have instructions on exactly how that is seen. That might be something that we can, as Mr. Evans has suggested, respond in writing to the PCRC.
Thank you for that.
I can now report on the COO situation. The interim COO is to be appointed until the new CEO has been found. There are still some steps before the interim COO can be appointed.
In respect of other matters that might impact on the suitability issue, first, in respect of the ownership of CRL and what one hears in the press, reads in the press about that. Is that not an instability issue that is relevant for the PCRC to take into account in determining suitability of CRL?
With respect, no.
And why not?
I don't see where the instability arises. This is a corporate transaction from a reputable private equity firm. They're about to make an acquisition if it proceeds. If they proceed to make the acquisition, then the transaction is completed. The scope of the capacity for that transaction to be completed will be subject to other regulatory approvals in any event.
Then moving on to the position in Melbourne and Sydney, can I put the same question to you in that context? CRL and or its subsidiaries in those jurisdictions have been found unsuitable to hold an Australian casino licence or to be closely associated with a casino licensee in those jurisdictions. Is that not a matter that the PCRC should take into account in determining the suitability of CRL and the Burswood entities?
Those matters can be taken into account, but they need to be taken into account in the present setting. The present setting being whatever ILGA decides to do with respect to Sydney, and there may be information about that before this Commission hands down its final report, and the circumstance that despite the finding in relation to CRL made in Melbourne, CRL is able to continue and Crown Melbourne is able to continue subject to the steps Commissioner Finkelstein recommended. So those are pertinent from the developments in Sydney and Melbourne.
Thank you. Under section 19, subsection 4 of the Casino Control Act, only the casino licensee can conduct gaming at the casino. Give you a moment to refresh your memory about that.
Yes.
Who conducts the gaming at Perth Casino?
Well, it comes back to the discussion that Commissioner Owen had with Mr. Evans. It's that the interrelationship between Burswood Limited, Burswood Nominees and Burswood Management is such that it's taken as a whole that Crown Perth is comprised of those entities, which includes the licensee.
No, that answers my question, Mr. Darmanander. Who conducts the gaming at the Perth Casino? Which entity conducts the gaming at the Perth Casino?
Well, it is with respect the same type of analysis as was the subject of discussion between Commissioner Owen and Mr. Evans, which is to say that the structure is such that in circumstances where, although Burswood Management and Burswood Nominees have particular assets or particular holdings, they're all done together with Burswood Limited. And it was the evidence given by Mr. McCann in relation to the centrality of the work of Burswood Limited.
So Burswood Nominees has no employees, has an executive board, and doesn't, as on Crown's position, operate Perth Casino. That's done at the Burswood Limited level, and it's governed at the Burswood Limited level. Is that right?
Yes.
So how can it be said in those circumstances that Burswood Nominees Limited carries on the gaming? What's the terminology? I'll just find it there.
Well, the subsidiaries act for the benefit of Burswood Limited.
Conduct games at the premises of the casino. All right. Situation is that BRML employs all the employees.
Yes.
How is that appropriate given that BRML has no assets? Therefore, no day-to-day, no assets.
Well, it's a structure that arose after the 1997 amendments and in circumstances where, as Mr. McCann said, they're all working together with respect to the Crown Perth Casino, with Burswood Limited being, in effect, either the sole controller or the sole shareholder of the relevant entities.
Is there any reason why BRML could not have a service agreement under which it agreed to supply the labour and BL or BNL agreed to, well, BNL really agreed to pay for it so as to regularise, I should say, the arrangement?
Well, informally, it seems to operate in such a way as Mr. McCann described, in the sense that the work of these two subsidiaries is done for the benefit of Burswood Limited, which exercises control over them, and implicit within that might well be an arrangement with respect to the sharing of resources or labour. But it's a matter that we can certainly consider and respond in writing if that's required.
I've been asking these questions for a year now, Mr. Darmanander. I think you've had time to respond, but in respect... Withdraw that I've just started. You spoke about it being inappropriate for Perth Casino to have, or Crown to have, an advanced level of maturity of its MLTF program before it can be found suitable. In that respect, can I ask you, would it be reasonable to require a more advanced level of maturity in circumstances where a casino licensee had previously failed to manage MLTF risk than in respect of a casino licensee who had not previously failed to manage the risk?
No. That the evidence given by Mr. Blackburn addresses that.
The tax situation, and I will have to consider, obviously, as I will, everything you've said, what you said in respect of tax. But should not the Perth Casino have paid tax on poker tournament entry fees?
Well, we've addressed all of this in writing. And
Well, I'm just wondering, because I thought that issue had been squarely raised with you, and yet you said in oral submissions that in effect we'd made no comment in respect of the tax issue, and only in respect of GWC communications or communications with the GWC about tax.
well, Commissioner, that's how we read the observations.
So that's what I wanted to make sure, that we were sort of on the same page about that issue. Are you saying that you haven't made submissions about the substantive issue about whether tax should have been paid?
So far as we read the observations, that substantive issue was not raised.
That's fine, Mr. Dharmananda. I'll accept what you say in that respect. I just want to make sure that we understand what your position is. And would you say the same thing about whether there should be a consistent approach to whether tax is payable on non-cashable credits at EGMs and table games?
Again, that substantive issue was not raised, but it is the subject of attention in the discussion paper that we sent.
When do you expect the RG expert to commence employment?
We don't know. There are certain issues in relation to approvals and visas.
And finally, I wanted to ask for some clarification on one of your very last submissions, to the effect that adopting a low threshold for casino gaming harm would be inconsistent with the position that the government had legalised licensed casino gaming. I just don't quite understand what you're saying there.
So it's a point that I think the GWC has made. It's this: if you adopt a low threshold for gambling harm, so according to Professor Rocklov, if you feel bad about losing at the casino, that's gambling harm, then adopting that type of approach to determining minimisation strategies runs the risk of challenging the revenue capable of being raised by a casino operator in relation to the licence that the state has decided to grant for the purposes of enabling recreational gambling. So you've got to be conscious of that threshold when you come to make determinations about reform. It's an important part of the analysis.
Thank you, Mr. Dharmananda. I don't have any further questions.
One, if I may, Mr. Dharmananda, you've sort of touched on the Melbourne arrangements. The Crown remediation plan seems to me to rely very heavily on CRL. You talked about AML and internal audit and those sort of arrangements. So to what extent does the success of the remediation plan in Perth rely on stability of arrangements in Melbourne, particularly given the light of the Royal Commission, the Victorian Royal Commission?
Well, there is an interconnectedness, we accept that, but the manner in which CRL would see the operations of its businesses would seek to ensure that Crown Perth can succeed, even if there are issues around Crown Melbourne.
May be an issue, but Crown Perth's in a position to deal with it.
Yes.
That's it. Thanks, Commissioner.
Mr.
I beg your pardon, Commissioner.
Mr. Dharmananda, can I start with the to come back to that, to the proposition of the special obligations and come at it in a slightly different way, because is there a way of looking at it in this sense to concentrate not so much on the special obligations of the licensee, but the special nature of the licence, and the concept that you have accepted of a corporate social licence, which isn't a phrase that I favour. I prefer the old terminology of corporate social responsibility, but it takes its flavour from context, and the special nature of the licence may well condition the corporate social licence, to use the terminology. And the special nature of the licence is that it is the only one in the state. I know that it is possible under the legislation to issue further casino licences, but it's operating in a protected environment in that sense. And it's in relation to the provision of services which are acknowledged to have the potential to cause harm. So that it has a special nature, that licence. Would that not condition the corporate social licence or the corporate social responsibility and give it some context and some meaning?
Well, the difficulty that one encounters immediately with that type of analysis, with respect, Commissioner, is how, what, and the critique that's levelled at CSR as a branch of corporate governance is to try to identify, in terms of brass tacks, exactly what it means to say there's a corporate social licence in a particular context. And that's where the academics who don't favour going down that path have raised the prospect that it's nebulous. It's not clear exactly what it means. We may recognise that a state agreement is a special privilege. Rio Tinto, BHP, they all enjoy the benefits of a state agreement in various areas. Do they then have a special responsibility and a special obligation by virtue of the entry into the state agreement? Or is it because this is in respect of an industry that has the potential to cause harm? Well, mining can too.
Can I come to the issues which have been raised with you about the working out, if I can call it that, the working out of some of the recommendations of the Victorian Royal Commission. And it's, if you look at recommendation 30, which is the independence of senior management, it's the independence of senior management from anyone other than the board, effectively of the board of Crown Melbourne Limited, so that a person in senior management could not report to a centralised CRL group manager. Now, I know this is only a recommendation, but it has been accepted in principle by the government. I think that's the terminology. Now,
yes, there are ongoing developments with respect to the implementation of those recommendations, and that is a matter that moves on a weekly basis, Commissioner.
It is, and that's what I'm going to raise with you. It puts us in a position where there's considerable uncertainty as to how do we measure these things. Now, if taken to its logical conclusion, that recommendation would have ramifications for the shared services model, wouldn't it?
It would, depending on exactly how it looks, yes. But one way to address that in your reports, Commissioner, may be to express such findings as one may wish to make on structure or governance as subject to any implementation of the reforms in legislation in Victoria.
Yeah. And then moving to recommendation 29, and you raised the issue of formation of actual board committees of Burswood Limited, or whichever entity it is. And common experience in the corporate world is that board committees work best when it's the independent directors that
Run them.
run them. Now, might that not be an argument in favour of a strengthening of the independent director component of the Burswood board?
It depends on how many committees one envisages. It also would have to work with analysis of the capacity for ex officio members of that committee to be in charge of it.
Yes. All right. Now, can I come to the structure? And as you heard me say to Mr. Evans, I'm still not sitting easily with me, and I'm hoping to get some assistance from you and perhaps others over the next day and a half to clarify my thinking on this. But the position that Crown is adopting seems to be that since corporatisation in 1997, it's Burswood Limited that has owned and operated the Perth Casino under the trust structure. But there's now, it's put in a slightly different way, that it's now it's the Crown Perth concept with the three entities working together, and that you find the answer to any problem that we might raise. You find the answer by saying, well, you don't have to identify an individual from within those three entities. You'll find the answer in the whole. Is that a fair summation?
I think it's a reasonably fair summation. The way that it's put suggests that we're seeking to evade the articulation of exactly who is responsible. It's more that it works organically in that way, and that's what it's been doing for a number of years.
Yes, well, that's what doesn't sit easily with me when you've got a trust structure. If it were simply a corporate group, the holding company working with its subsidiaries would be much easier. But you've got a trust structure, and this is not a flight of fancy by some academic equity lawyer, because these things can have consequences under the law of trusts. But there are obligations which are extant in the trustee. They've never been changed. When the changes were made to the state agreement and ratified by Parliament that implemented this corporatised structure with Burswood Limited as the body in whom governance seems to reside, overall governance seems to reside, the trust structure was left in place, and it's still there, and there are obligations. And just as an example, Burswood Resort Management Limited has the obligation to manage any business conducted by of the trust fund. Now, I will read once again your written submissions as to why Burswood Resort Management is actually doing that and complying with the trustee. But at the moment, I'm struggling with it because it seems to me that the mere employment of staff that you make available to someone else when you have no assets, no capacity to direct the staff, whether that's conducting a business is So I'm still struggling with that.
Yes, the distillation of our thinking on these questions is set out in writing, and some of those concepts are subtle. We accept they are subtle, but the way that we conceive of things is as I have explained this afternoon, and it's best reflected in writing in chapter.
Yes, yes. But if I could just raise a couple of other examples. If Burswood Limited is the boss, if I can put it that way, to use the vernacular, there's clauses 20.1 and 20.2, I think it is, of the trust deed, which says that a unit holder cannot interfere with the operations of the trust and is not entitled to exercise any rights or powers in relation to an authorised investment. And of course, the casino licence is an authorised investment. So that if Burswood Limited is directing the operations of the casino, it is, at least theoretically, in conflict with the trust deed.
Except if the trustee authorises that behaviour and approves of it and works collaboratively with it. So then that's not an interference. It's not an interference if the trustee's involved.
I wonder about that. How far can you take that?
Well, to the extent that there are established rules in relation to the performance of trustees, then a trustee that participates, is aware of, condones, and otherwise approves of behaviour, it can't be heard to say that the intermeddler is in charge.
Well, that might mean that it's not actionable by the trustee or the unit holder, but it still might be contrary to the trust obligations, mightn't it?
It depends on exactly what might be had in mind, but one would have thought that consent would be an answer to most things.
All right, only one more example. At one stage, there was inserted into the trust deed a clause, I think it's 2A, which allowed the trustee, gave the trustee the power to delegate its responsibility. In the 12th supplemental deed in October 1997, that was removed. Now, you take a situation where in AML, Burswood Nominees Limited, which is said to be the provider of the provider of the designated services in relation to the operations of the Perth Casino, has delegated its AML functions to Crown Resorts Limited as a member of the
Designated business group.
Designated business group. Again, at least theoretically, is that not in breach if there's no authority to delegate?
Again, we come back to the point about consent, Commissioner.
Well, I've still got some thinking to do, and I will read your submissions again.
Commissioner, in the observations at paragraph 37, Chapter 3, page 164, there are certain remarks made by those who drew this part of the observations with or without input from the commissioners, but that seems to record some thinking which reflects our own. Is the functions relevant to the board, and I detailed how that is to occur in the future by reference to the Charter, and the evidence given by Mr. McCann was that the subsidiaries work together with and for the benefit of Burswood Limited, and so to that extent there might well be, in certain instances, delegations to particular persons within those two entities.
Right. I think that probably is enough. All right, Mr. Dharmananda, thank you very much for your submissions. They have been of assistance, and we'll now adjourn and resume at 10 a.m. tomorrow. Thank you.
All rise.